Hello and welcome back to Malone Hatley's podcast. I now pronounce you divorced. Today we are joined by JeBria Wilson, one of our attorneys out of our Columbia, South Carolina office. JeBria, thanks for joining us.
Of course, Dan. How are you?
I'm doing well. As we ended 25, we were talking about things to look out for, what to do during the holidays. Basically, trying to prepare as best as you can for events that we know are coming up, the holidays, and what to do if there's children involved, or if you're considering or contemplating filing, what does that look like filing now, or should we wait until next year in 2026? Well, that time has gone by so fast. And here we are almost at the end of the first month of the new year here. And so we wanted to talk about what does that look like when we're filing, when you're wanting to think about filing. And I know in your experience as a civil litigator, you've probably seen it all, just kind of what to do, what not to do, what to watch out for once something has been filed. So maybe if you don't mind, just introduce yourself, your experience in the family law sector, and we'll just kind of go from there.
Sure. Well, my name is JeBria Wilson. I was a juvenile solicitor for Richland County for about a year and about 8 months. During that time, I was almost exclusively in the family court. I appeared in court almost every day. I saw my primary focus was juvenile criminal offenses, but I did a lot with custody, with parents, with high conflict situations, and so does a lot with that. And then in my time kind of waiting for the court to start, I saw a lot of divorces and name changes and all sorts of other stuff that we use here.
Sure. And so when you say high conflict, what did you witness?
A little bit of everything, too much sometimes. So there are parents who want the best for their child, but they have a parent that they're trying to co-parent with outside children or children with someone else, and it can become a high conflict situation when it's just trying to figure out what to do with these kids and figure out what exactly is the best interest of the child, which is pretty much the focus in South Carolina and what happens with.
And when you're dealing in these types of situations, just from your own experience, for those who are tuning in, what can someone do to maybe try to prevent their case from escalating to be a high conflict case?
I would say keep everything in writing rather than getting on a phone call, doing something that's volatile with someone you know you have a conflict with. Keep everything in writing, send them a text versus a call, or schedule time for them to see their kids or to sit down and have a conversation. Another way, if it is too high conflict and text messages don't work, things like that, maybe a public space. So ask to meet at a coffee shop to have a conversation about what exactly you want to do with your marriage, what you want to do with your custody situation, and things like those. A lot of times, things being in writing is super, super helpful for us as attorneys later to just kind of show how the parenting relationship goes and how the divorce relationship goes. A lot of times, things are about reasonableness. And so, being reasonable with your requests, with the things that you're asking for, those are the things the court really looks to.
We've talked about that as well on prior episodes, just documenting things in writing. From where you sit in your perspective, how important is it to make sure that even though you're documented in writing, what you say is actually just as important besides just actual documentation itself?
So, the things that you say are incredibly important, not only for us to have a full view and understanding of what's going on with your situation. So, we have everything that we need to prepare for court or an appearance in front of the judge. So, it's really important the types of language that you use, try and be cordial, try and organize your thoughts, before you have a high conflict conversation with someone, maybe have some writing points or some talking points that you'd like to hit. Have an idea of what exactly you want to do before you go into some sort of high conflict situation.
Yeah, because in my experience, things that are put in writing can be taken way out of context. And it's all about how the person receiving it, which could then potentially escalate into something that wasn't even intended. So you're having unintended consequences. When you're following up in writing and you just want to document it for the sake of your case, is there any tips you have for clients on maybe best practices on how to do that?
Personally, for just in general and in life, like my emails, I have a timer on my emails as they go out for 30 seconds, to take a second, look at my emails before they go out, see if there's any typos, see if there's anything that's incorrect in the email. So I think what's important is to kind of take some time before you send something that you'll regret later. So really take the time to like look and think before you go through things, which is why I'm a huge proponent of a list. So list out the things that you want from your marriage. If it's alimony, if it's child support, if there's something that you'd like to include in your agreement, make sure to make that note. Note all the things that are important to you. Note the things that you have been doing. Note the things that you need to do going forward and the needs for yourself and for any potential children that are involved in a divorce or any sort of incident like that.
Yeah, and that's such good advice. I'm always advising clients as well. Read it out loud, run it by someone that you trust, maybe even your lawyer, just to make sure that there's not besides unintended consequences from the person receiving, but maybe legal implications that you're not aware of. And you just want to make sure that you've got your lawyer's eyes on it to see if there's anything that you need to add or anything that you need to change, things like that. When we're talking about putting things in writing, sometimes clients will send something and they'll regret it. And then they'll say, oh my gosh, what do I do? Should they go ahead and delete that message? Or is it, all right, now I need to call my attorney because I sent something that I probably shouldn't have?
I think tell your attorney as soon as possible. Anything we don't know about, we can't account for. Doing stuff like that and making sure that you have everything in order first for your attorney, good or bad, tell us because we can't prepare for it otherwise. So make sure that you go through your text messages. Don't send anything in anger. That is my one thing. Take a moment to really think about and process everything before you send them out.
Right, exactly. And we also don't want to be in a position to where if they sent something and then they delete it, there could be potential spoliation of evidence, and that could have, stick with the idea of unintended consequences. It could really be detrimental to your case, and it may be something so innocuous that it wouldn't have affected it, but yet for you deleting something, it gives the appearance of maybe impropriety, dishonesty. And in a lot of times in family law cases, absent jurisdictions that have juries, which are very far and few, the judge is going to be really basing his or her decision on you and the other side. And so they're going to be judging it on the veracity and the credibility of you as a witness. And if you're deleting things, then that potentially could be the game changer. Also, there's a lot of local rules that once a filing is in place or there is contemplation of filing, you have to preserve everything. And so if you start deleting social media accounts or deleting posts or tweets, whatever the case may be, then that could jeopardize or compromise your interest as well. In your situation, in cases you've either tried yourself or been a part of as a family law solicitor, what were some of the mistakes that parents made that may have swayed the judge or may have gotten them a decision that really wasn't what they wanted or favorable to them?
The two main things were being unprepared and outbursts in court. No judge likes an outburst in the courtroom. For making sure that you have everything you need, if you hear something that isn't quite accurate, keep a notepad with you, write it down so we can know about it and address it later. But in the moment, don't interrupt. Those things are incredibly important. The judge is listening and trying to hear everything to make a decision. So really sitting back, managing yourself, managing what you've got going on first is key to making sure you have a really coherent case. And the second part, like I said, is preparation. So know going into court what the hearing is for, know what exactly the basis of the hearing is. Know the things that you'd like for the judge to know the things that you'd like your attorney to know, things that you feel are really, really important, especially with custody with children. We don't get to meet your kids like that. So we need to know what the situation is like so we can fully prepare and fully present all your arguments in a way that makes sense to the judge and makes sense to the court in total.
You raise a lot of really good points. When I'm with a client in a hearing, I'll give them a pen and a notepad and just tell them, just write things down, write your thoughts down. So then when we take a break or we recess, we can go over it so then I can address it with the court if I think it's something that's important or needs to be addressed. But in your experience as a litigator, how do you prepare your clients for these types of hearings? Because your point's well taken. You need to communicate with the lawyer, let them know exactly what your expectations are, but the lawyer needs to manage those expectations and also needs to set expectations of this is what may or may not happen in court, but this is how I need you to really present yourself in court, not just from how to testify, but also to your point earlier, just sitting there at the table and listening and making sure that we're really eliminating these emotional outbursts.
Sure. I'm a person that has my emotions written all over my face. So there are a lot of people that are like that. So just manage your expectations when you go in. Sometimes the judge makes a ruling that is totally against what we talked about. I like to meet with my clients before we do anything, just to kind of explain courtroom etiquette, which is pretty much stay to yourself, speak or don't speak unless spoken to. Have your notes together on the side, know that I'm prepared for the hearing. If there's something you'd like me to know before the hearing, let me know in advance. I'd also say make sure you give the court the proper respect with how you dress, how you appear. I'm not saying that you have to dress up as if you're a wedding guest, but make sure that you're not, wearing jeans, t-shirts, tank tops, and things like those. Show the court that you care about the proceedings and show that you're presenting yourself in a way that makes sense.
Hmm. That's well taken. In your experience, when you're dealing with these high conflicts, there's children involved. So, what types of documents do you want your clients to preserve and or bring to their meeting with you in preparation for any type of hearing? Because when we're talking finances, we need to get a hold of any financial documents or tax returns, W-2s, retirement statements, mortgages, things like that. But when we're dealing with potentially high conflict custody cases, what sorts of documents are you looking for in moving cases forward and representing the clients?
So I personally like to see via text if there has been attempts at a co-parenting plan. If you have been trying to be reasonable with the other side in your case, just shutting down communication completely isn't the best interest of the child. The standard in South Carolina is making sure that the child and all their needs are being taken care of. So text messages to show, coordination for pickups, documentation of daycare, and documentation of how much you spend on a daily basis. So going to court and being able to show that is incredibly helpful. Something else that's helpful are healthcare insurance, dental insurance, all sorts of different plans, who's paying that, what's the frequency, if there have been payments. There are situations right now. I have a client who's separated from their significant other, but the other person is still paying child support without an official plan in place. So if this dollar amount is working, if that's something that you all have agreed to in a co-parenting plan already, the court will be more likely to grant something like that because it's already working and you want to have the least amount of friction possible in dealing with situations like these.
Right. And you just brought up something I think is interesting. The word precedence comes to my mind. What emphasis does the court place on how things have been going that are kind of leading up to appearing in front of the judge?
Well, I'll say this: judges aren't stupid. They've seen a little bit of everything throughout their career. So if there is a low conflict situation that's been fine, just passing by, and then all of a sudden it becomes high conflict, the judge is going to ask more questions like, is there a paramour? Did something change in the relationship? Is there a new job? Is there something else that's happening? So being prepared for all of these questions and prepared for why there's been some sort of huge change in the circumstances is incredibly important to make your case and to explain things to the judge, and also be clear in what you're trying to ask for from the court.
Exactly. And just because things have been going a certain way doesn't always mean that that's what the court's going to order. Because you can be in a situation where it's not working and you can advise the court, listen, this is what is the current status quo, but it's not working because of X, Y, and Z. Have you been involved in situations like that?
Yes, all the time. When I was a solicitor in South Carolina, it's called the Department of Social Services, so DSS. When I had cases involving DSS, a lot of times there would be one custodial parent that would be taking care of the child. The child would be having some sort of behavioral issue or some other personal issue that's going on, whether that could be children get addicted to drugs and have adverse behaviors. There's a lot of different things that can come up. A new diagnosis for some sort of ADHD diagnosis, or some sort of any sort of diagnosis, children who have cancer diagnoses or other types of sensitive health matters that need to be addressed. So all of these things are incredibly important, especially to involve all the parents that are involved. Sometimes it's grandparents that are also involved. So it's really just trying to have a good understanding of the family dynamic, and you as the client inform me about what it is that we have to do and what that's like so we can direct your case in the best way.
Yeah, yeah. And also when you're talking about these medical appointments, and I'll even throw in parent teacher conferences and really extracurriculars, anything that involves the child or the children, is it really good advice to say, listen, include the other parent? You may not like them, you may not respect them, but you need to include them because they are the.
I would say do a balancing test. If it is more harmful to the child or to the medical provider that's doing something like that, or to the teacher, maybe do alternates. Just it's really dependent on your situation and how the co-parenting relationship works with the other party. But the main thing is making sure that all information is shared. Although you may not want someone at an appointment, inform them still and be like, hey, I've done this on my own, but here's what happened in the appointment. The next appointment that comes up, you can take them, but please let me know what happens. And so a court would look favorably upon something like that because you're showing that you're being a parent that can try to do the best thing for the interest of your child. And so that's what the court really, really focuses on.
And that balancing act is so hard. I agree with you. Loop in your attorney. Any questions, any doubt, any pause, make sure that you're involving your attorney often and early so informed decisions can be made, because you may have those unintended consequences that we are talking about in the beginning of the podcast, which is you think you're looking out for the best interests of the child, but really you're giving harm because you're not including the parent, or you're including the parent, but you're not really accomplishing what needs to be done. And it's a really hard balancing act. And that's a great point that you made. Bria, I want to thank you again for taking time. I feel like we kind of just scratched the surface on high conflict cases and really what they are. And is there a way that we can try to mitigate some of these issues from rising to that level of potential high conflict? So thanks for joining us today.
Absolutely. Thank you for having me, Dan.
And for those of you who are listening in, if you think you're going through high conflict or you have any questions or concerns, give Melone Hatley a call and give us an opportunity to at least speak with you so we can advise you on what needs to be done next to hopefully try to protect your goals and your interests. And lastly, don't forget to like and subscribe and share this podcast. We really do appreciate all the 5 stars that we get and all the feedback. The questions are great, and we do try our best to answer those in future podcasts. Thank you.
Thank you.